McNamara, the Whitcourt staff, supporters and fellow defendants from far and near. My name is Ed Kinane. This evening, I am giving the first of two opening statements on behalf of my 15 fellow pro se defendants. To briefly introduce myself, I am a survivor of the murderous shot in awe in Baghdad in 2003, and most recently, a sojourner for 30 days in war-torn Afghanistan. As you may recall, sir, I am also a convicted Hancock 38 defendant. I have served 2 sentences in Jamesville Penitentiary for my peaceful opposition to the drone crimes at Hancock Air Base, the home of 174th Attack Wing. With the court's permission, I would ask that before we proceed, we observe a moment of silence. During this moment, I ask that all of us present reflect on the children and other non-combatants killed and maimed by weaponized drones during the current protracted wars in Afghanistan and other Muslim lands. Thank you. It is very important to us that we not lose sight for even a moment of why all of us here are here in this courtroom tonight. Our defense this evening can be seen as proceeding along 2 paths. One is the path of legalism. The other is the path of justice, lit by the light of conscience. All too often in this dark and bloody world, these paths widely diverge, but occasionally they crisscross. And this evening, Judge Gideon, will show that for us, these paths converge. Our fervent hope is that these paths, legalism and conscience, also converge for you. This evening, we pro se defendants will address both the role of conscience and that of law in shaping our intent and motivating our action at the Hancock drone base on October 25th, 2012. Now, some here tonight may not be familiar with what we mean when we say we are pro se defendants. Pro se simply means that we will be speaking for ourselves, voluntarily foregoing the benefit of an attorney's trial experience and expertise. It is important to us, individually and collectively, that we use our own words, our own voice, to explain why we acted as we did on October 25th, 2012, over 14 months ago, and why we keep trying to draw attention to the shameful role of the Hancock drone base. And before we proceed further, let me remove a likely area of confusion. Some may think that our action at Hancock on October 25th was a form of civil disobedience. Civil disobedience generally implies the deliberate breaking of law to expose the unjustness of that law. For example, defying the laws and courts underpinning apartheid in South Africa, or the laws and courts underpinning slavery and segregation in the old U.S. South. Let me be clear. On October 25th, in supposedly trespassing or supposedly committing disorderly conduct, we did not commit civil disobedience. We did not break the law. We came to uphold the law. We will note that on October 25th, 2012, we acted consistent with and inspired by the Nuremberg Protocols, initiated and signed by the United States. The Nuremberg Protocols mandate that citizens of all nations expose and refuse to participate in their government's war crimes and crimes against humanity. We will note that our actions on October 25th were consistent with the United Nations Charter, to which the United States is signatory. We will note that such documents as the United Nations Charter are treaties. And so, under Article 6 of the United States Constitution, are the highest law of our land. Highest law means that such international law trumps federal, state, and local law, and applies in federal, state, and local courts. Judges in these courts are bound by their oaths of office to apply such law. For judges to evade such law has not only grave legal, but also moral implications. All of us this evening are faced with two charges: trespass and disorderly conduct. Tonight we will parse the elements of the trespass charge and show that, in fact, we were not guilty of trespass in the easement area outside Hancock attack base. We will show that our presence outside Hancock on October 25th was knowingly not a matter of trespass, but rather was integral to our protracted campaign necessary to save lives. The lives of children and other non-combatants in Afghanistan and elsewhere. And I must say, the logical and causal connection between our action and those victims is infinitely closer than that between those victims and the perpetrators of the 9/11 tragedy, none of whom were Afghan, and most of whom were from a U.S. ally, Saudi Arabia. We will parse the elements of the disorderly conduct charge. We will show that we were anything but disorderly at Hancock. We will show that we were orderly, both in the legal and the vernacular sense. We will demonstrate that our intent was anything but antisocial. We will introduce into evidence the brief nonviolence pledge that we each recited together immediately prior to heading out to Hancock on October 25th. With your permission, sir, we will read aloud to the court that pledge. That nonviolent pledge faithfully reflects our orderly, peaceful, and respectful frame of mind as each of us embarked on our mission that day. Our various testimonies, individually and collectively, will show, Judge Gideon, that on October 25th, our intent was not to cause public inconvenience, annoyance, or alarm, or recklessly create a risk thereof, but rather our intent was to uphold the law. On October 25th, our intent was clear and unambiguous: to uphold the U.S. Constitution while exercising our First Amendment right to petition our government for redress of grievance. And not incidentally, our effort to uphold the U.S. Constitution meshes exactly with the obligation of U.S. military and law enforcement personnel, whom we understand swear to uphold and defend the Constitution. We further understand that judges presiding over all U.S. courts likewise swear to uphold the Constitution. On October 25th, our intent was to uphold the Nuremberg Principles, the Geneva Accords, and international treaties entered into by the United States. Our intent was to honor our faith and our consciences, to uphold the highest ideals and mandates of our Judeo-Christian and Muslim heritage, especially thou shalt not kill. At a strategic level, our intent was and remains to address the Hancock personnel and chain of command, the public traffic along East Malloy Road, and via the media, the larger public, including this court. On October 25th, we sought, unsuccessfully, to convey to the Hancock Attack Base Commander a people's indictment co-authored by former U.S. Attorney General Ramsey Clark. That people's indictment enumerates the layers of law we persistently seek to uphold and that Hancock persistently violates. To further demonstrate our peaceful intent, we will display here images of the banners and placards we brought to Hancock on October 25th. These will make perfectly clear our determination to uphold law. We will hear testimony from pro se defendants James Ricks, Judith Bellow, and Patricia Weiland, each of whom, on October 25th, 2012, had just returned from a human rights fact-finding mission to a remote and dangerous corner of Pakistan close to the Afghan border. Shortly before October 25th, they had shared their grim findings and encounters with many of us defendants. There in the borderlands, they met with survivors of clandestine and illegal drone attacks, as well as with refugees fleeing from the terror of those attacks. Attacks which recklessly and with gross negligence trespassed on sovereign territory, and whose cowardly and disordered conduct shames us all. I believe, Judge Gideon, that we're going to introduce an amicus brief by Professor Mary Ellen O'Connell regarding the illegality of murderous drone strikes. To augment our testimony, we had expected to call expert witness Mr. Ramsey Clark to the stand. Mr. Clark was the U.S. Attorney General under President Lyndon Johnson. It may fairly be said that Mr. Clark is among the foremost practical experts in international law, both here in the U.S. and courts throughout the world. You'll recall, Judge, that Mr. Clark had already been qualified in this court, and in November 2011, previously testified in your court on behalf of the Hancock 38, also prosecuted for trespass at Hancock. Mr. Clark was to testify that the elements of a trespass charge did not apply to our actions at the Hancock drone base. Unfortunately, Mr. Clark's flight Friday night from New York City, due to the storm, was canceled. Mr. Clark's absence is a loss for all of us. And by that I mean not only the defense, but everyone here. Judge Gideon, my fellow defendants will refute the prosecution's charges, and we trust make it quite impossible for you or anyone committed to law and to justice to find us guilty, and certainly not guilty beyond the shadow of a doubt. Finally, let me reiterate, we did not come to Hancock on October 25th, 2012 to break the law. We came to uphold the law. So I thank you, sir, and all those present in advance for your keen attention to our testimony.
Thank you.
Wow. Grateful for this day and for this time that we have here together. My name is Clare, and I'm one of the 16 on trial this evening. I'm from Ithaca, New York, where there is a growing practice of acknowledging the land that we live on. In Ithaca, we live on Cayuga people's land. The land was slashed and burned and stolen from the Cayugas during the Sullivan-Clinton campaign ordered by George Washington in 1779. The land we live on has been occupied since that time. Gratefully, there is a growing movement to make amends, but we have a long way to go to honor the treaties that the U.S. government has violated in regard to the Cayuga people. Here in DeWitt, we stand on Onondaga land. The sovereign nation of Onondaga is just south of us, but this region has been Onondaga for millennium. there's much to do to make amends and honor the treaties made with Onondaga. I am grateful for the neighbors of Onondaga Nation who are committed to making this amends, to being better neighbors. We are on trial here in a court of law, accused of breaking the law, but firmly believe that we are upholding the law in our actions at Hancock. I would like to speak about the law and start by just saying that law is here to serve humanity, not the other way around. True law is here for the well-being of the earth and all her people, not just the well-being for a few, and not just well-being for powerful, not just the well-off, not just U.S. citizens, and not just white people. Over the past 100 years, some very important laws have been signed and agreed upon by nations around the world that reflect values of peace, freedom, sovereignty, equality, inalienable human rights, and the preciousness of all children. If we think that these laws were birthed by people in high places, we have failed, I believe, to recognize the movement of the Spirit. These laws have come into being by the movement of the Spirit, the groaning of humanity, seeking justice, seeking peace, seeking freedom, equality, freedom from tyranny and terror, seeking well-being. If we think that once these laws are made that the story is over, I believe we missed the mark again. In the same way that the laws came into being with the movement of the Spirit, these laws must be kept alive by the movement of the Spirit. A law that is not lived does not have life, and it might as well be dead. When we go to Hancock, we go to call a halt to drone war crimes. We breathe life into the laws and treaties and agreements designed to lead us toward peace and away from war. To name a few of these laws and agreements that might be lost in the mix of our culture, that would tell us otherwise. There are these laws that are the supreme laws of our land that all courts, as Ed has said, are bound to uphold. These laws forbid wars of aggression. Wars of aggression is a crime against peace, and it is considered the mother of all war crimes, the mother of all crimes. There are laws that forbid the killing of civilians, laws that forbid the use of weapons that do not discriminate between combatants and non-combatants, laws that forbid extrajudicial killing and the denial of due process, laws that would forbid a double standard that would protect some people and their human rights and not others. In closing, I would like to share the words of Ella Baker from 1964 that's sung in a beautiful song, and I've adapted them a little bit here. Until the killing of brown, black, and Muslim men, brown, black mothers' sons, become as important to the rest of the country and all of us as the killing of a white mother's son, we who believe in freedom cannot rest until this happens. Thank you.